Hello and welcome to our property damage blog on vicarious liability. I'm Rachel Eardley, an associate here at BLM, and I'm joined by my colleague Caroline Kane, partner in the property damage team. Today, Caroline and I will be discussing some of the most recent case law relating to vicarious liability and how this may be applied to property damage claims. So, Caroline, let's start with what vicarious liability is. It's where you're liable for the actions of your employees unless they're off on a frolic of their own, isn't it?
Well, yes, except that nowadays they don't have to be an employee, and there's quite a grey area as to what might constitute a frolic of your own. At its heart, the law says that for one person to be made liable for the actions of another, you've got to show two things. Firstly, you've got to show that there is a relationship between the two parties that makes it proper that one party should pay for the fault carried out by the other party. So that is going to be an employee or a relationship that's close to employment. So employment in all but name. And then the second thing you've got to show is that there is a connection then between that relationship and the wrongdoing that has actually happened.
So what has the most recent case law said?
Well, the most recent case law that we've had specifically about vicarious liability were two cases that were published by the Supreme Court on the 1st of April last year. Two massive Supreme Court decisions. They did come out before lunchtime and it wasn't an April Fool. These were the Morrison's case and the Barclays case. The Morrison's case concerned the actions of an employee who had gone off on a frolic of its own and uploaded large amounts of personal data from Morrison's payroll onto the internet. And so that case touches on what is and what is not an action within the course of employment. And that, I think, might have to be a topic for another time. But in the Barclays case, what they were focusing on there was talking about who it is that can be vicariously liable and for whom can you be vicariously liable.
Right, so was that about it not needing to be an employee?
Yes, this is absolutely the case that's talking and building on the law that has moved right from sort of back in the 1800s when it's talking about an employee and were they acting in the course of their employment or off on a frolic of their own, hence where the phrase comes from. But in Barclays Bank, this is a case that was talking about historic medical examinations that were performed by Dr. Bates on behalf of Barclays Bank in assessing applicants for employment. And it's emerged that during the examinations for which Barclays had sent their prospective employees, Dr. Bates had sexually assaulted the claimants. His victims only attended his practice because they had to, because they were sent there by Barclays. They otherwise would have had no contact with him whatsoever and wouldn't have been assaulted. But the other thing that was interesting was that only some of the work which Dr. Bates undertook was for Barclays. He was not their employee. He had a portfolio practice and he did work for a lot of other companies. So the question before the court was, how far and to what extent is Barclays going to be liable for the actions of this doctor? And it was an interesting one because the victims were going to get nothing if Barclays weren't made to pay up. Dr. Bates had died and his professional indemnity insurers are not going to be paying out for deliberate criminal conduct. So there was a fair amount of political pressure on the court. And the claimants sort of took that and ran with it and made much of an earlier decision that's referred to as the Christian Brothers case, which talks about the circumstances in which it would be fair, just and reasonable to impose liability. And they really focused their approach and their arguments on saying we have to find out in what circumstances is it fair, just and reasonable for somebody to be liable for the actions of another. And in a unanimous judgment, Lady Hale said, well, hang on a minute. We can't quite do that. If we go down that road, we are going to be completely changing the law in this area. And what Lady Hale said is actually nothing in the previous case law has eroded the distinction between the relationship of employment and quasi-employment and relationships that are an independent subcontractor. And she said you can use policy considerations to give you a steer, but nothing fundamentally replaces the factual analysis that you carry out of the relationship that you have to determine is it employment or quasi-employment, in which case liability can then attach. And in this case, they said, well, we're hugely sympathetic towards the claimants, but we need to look at what this relationship was. And Dr. Bates, because of his own independent practice and the work he carried out for numerous other people, he was an independent subcontractor. The independent subcontractor at defence applies. And so Barclays, I'm sure to their relief, was not considered to be vicariously liable for his wrongdoing. The other thing that's notable about this case is that the Supreme Court was really offered the opportunity to make a comment on the category of worker, which is a specific employment term. And they avoided the question and said that they did not want to say that vicarious liability is automatically applicable where you have a worker as opposed to an employee. So they didn't go there, but it's still a category that's rather up in the air.
So what is the position with Limb B workers?
Well, Limb B workers are this particular class of worker. They are, in name, contractors, but they're not really independent subcontractors, and they're not employees either. They're sort of somewhere in between, a bit of a halfway house. The reason that they're important is because as workers, they attract employment rights. It's very clear when we're looking then at vicarious liability and workers that being a worker doesn't automatically mean that they are someone for whom, if you contract a worker as opposed to employ an employee, you're not going to be automatically vicariously liable for them in the same way that you might with an employee. But it is always going to be true that the nearer the relationship is to being an employee, the easier it is to say this is a relationship akin to employment.
So is that what the Uber drivers were arguing about?
Yes, the Uber drivers and Pimlico plumbers and Deliveroo and Addison Lee, they're all employment cases that have come out of the gig economy. The gig economy is trying to run a business based on employing independent subcontractors so that you don't have to deal with the messy bits to do with actual employment law. But in these cases, all of these cases involve Limb B workers trying to argue that they are Limb B workers. So they're all employment cases in which a self-employed worker was seeking employment rights like minimum wage, sick pay, holidays, by saying we are workers and we have rights. We are not subcontractors who don't have rights.
So how does that impact claims for vicarious liability?
Well, it's all to do with this relationship akin to employment part of the test. So even though the Supreme Court avoided the opportunity to say you can be vicariously liable, or you are definitely vicariously liable for the actions of your worker if it was within the course of their work, being categorized as a worker, as I said, I think keeps the vicarious liability option open. Independent subcontractors do not attract vicarious liability. If you have an independent subcontractor who has done something wrong, you can pass a claim in negligence off onto them. Workers, the situation is more nuanced. It's not certain that you are vicariously liable for them, but it's not guaranteed that you're not. So we look at the categorization of these parties who are presenting employment claims to see where's this boundary between maybe we're vicariously liable and no, we're definitely not vicariously liable.
Okay, so what does it look at? What are the key factors and how do we apply it to any of our claims?
Well, one of the key things that applied in all of those cases that I mentioned was that they all work for their, in inverted commas, employer, the contracting party. So when we look at Pimlico Plumbers, which was one of the earliest cases that came out on this, the gentleman in question was bringing a claim because he wanted sick pay and health rights. He drove a Pimlico Plumbers van. He had Pimlico Plumbers branded clothing. He had a Pimlico Plumbers phone. He only ever worked for Pimlico Plumbers and had done for years and years and years. It was the classic, slice a stick of rock and he said Pimlico Plumbers all the way through it. That has rather changed. So at the point of that decision, a lot of the court's focus in reaching the judgment, and they found for the individual, was all on the external appearance. What did he look like? What was he presenting as? By the time we get to the most recent of all these gig economy employment decisions, which is the Uber case, in that one, we're in a very different situation. And Uber drivers don't wear a uniform. And in London, Uber drivers are specifically told not to advertise the branding. But in Uber, the Supreme Court really focused on the degree of control that was exercised by Uber over their drivers. And it found that Uber drivers are workers, and so they have rights. But in looking at the degree of control and what Uber did, they really focused on things like the fact that Uber fixes and controls all the prices. Uber decides the contract terms. They're fixed. That neither the passengers nor the drivers can negotiate any kind of their Uber contract. Once you're logged into the Uber app, a driver's freedom to accept work or reject work is restricted. Uber exercises all this control over the delivery of the service. And things like the fact that passenger feedback is collected But it's not used for marketing. It's not given to the drivers to say, oh, you did a great job here. It's used for internal performance management. And that starts to sound very employee-esque. Essentially, Uber keeps their drivers and their passengers at arm's length. That's their business model. They want people to have repeat custom through Uber, not repeat custom because the same Uber driver has taken them on the same trip, every week for the last 6 months. And so it removes, as far as possible, the potential for drivers to market their own services to the passengers. So the drivers don't have an ability to build up their own business separate from Uber. They are sort of enthralled to Uber all the way, as part of the business model. And so that's why the court found that they were workers and in that relationship.
So what would that look like in a property claim?
Well, as we said, the closer you are to being an employee, the easier it is that someone's vicariously liable for you. And the closer you are to being a worker, the easier it is for there to be a potential argument about vicarious liability. So let's try and put it into a practical example. Let's say that there's an insured that's carrying out redevelopment works to a house, and they engage Mr. Tap, the plumber, to do some plumbing works. He makes a mistake. A couple of days later, there's a massive flood which affects the neighbour's house. And so the neighbour's property insurers pick up the file, and they're going to come after somebody in negligence. But who? Our insured or Mr. Tap? Well, we say, well, Mr. Tap isn't an employee, he's a contractor. He does all of his own paperwork, he files his own tax returns, he's nothing to do with us. Off you go in your claim of negligence, go and have a chat to Mr. Tap. But what if Mr. Tap has only worked for our insured's projects for the last month? Does that make a difference? What if he's only worked on the insured's projects for the last 2 years, or has been working for us consistently and solely for the last 10 years? What if our insured liaises with the clients, all of the clients that Mr. Tap works for? So Mr. Tap has no direct contact with anyone. And coming back to Pimlico plumbers, what if Mr. Tap does turn up wearing the branded uniform and uses the computer system and has the van and the phone and all the rest of it? You can build it up layer on layer, and you can see how you can have two very different situations covered by the same initial description. Mr. Tap is a contractor. Is Mr. Tap an independent subcontractor? Or is Mr. Tap a worker? And if Mr. Tap is a contractor, we can pass on a claim. But if Mr. Tap is a worker, then there's a real risk of the next door neighbour's property insurers or their terribly clever solicitors coming along and saying, oh, hang on, you're vicariously liable for his actions, so you're another pot of money from which we might seek to recover.
So with the expansion of the gig economy, it seems like there would be an increase in the number of people who count as workers, which is good for them, and it stops employment rights being eroded by forcing people to be subcontractors. But it doesn't sound like it's good news in terms of vicarious liability.
Well, it probably depends on which side of the fence we're on at any given time. If you're coming at it from a claimant perspective and trying to make a recovery, then having another recovery target to consider is always going to be a good thing. It maximises your chances of being able to make a recovery. From a defending point of view, it's obviously not a good thing if your insureds who don't think that they're going to be liable for the actions of someone they are contracting suddenly find that actually there's a bit of a grey area, and maybe they are responsible for someone who they thought was completely independent. It's an interesting one because leading up to the Morrisons and the Barclays judgment, we've had lots of decisions that had chipped away at the independent subcontractor defence. If we go, again, right back to our sort of 1800s cases and the employee on a frolic of their own, etc., that was very focused on, are they an employee? And for a long time, the question is, are they an employee or are they not? And then we had lots of different cases that gradually eroded away at that and said, well, employee, we can't use that as the test anymore. We've got to look at the relationship. And there was this feeling going into the Barclays decision of, is this independent subcontractor defence going to survive? Is the court just going to keep going with the same momentum that the end result has to be that independent subcontractor defence isn't a thing anymore? Well, the Barclays decision sort of put a line down and said, no, absolutely, independent subcontractor defence still survives. Nothing in the previous case law has eroded this. Some slightly creative thinking perhaps to get there, but that's what they said. And it's very clear cut. The problem is, well, that's all well and good, but what's the point of a defence if no one falls in the category who can benefit from it? the more we broaden the category of workers, the more that independent subcontractor defence, I think, has a risk of being eroded by the back door.
Yeah. So what do we want to look out for then?
Well, the first thing with all of these types of cases is to see whether the decisions are being followed. And so far, the answer is yes. Addison Lee is another setup that's very similar to Uber, and their workers had made a similar claim. But the court deferred the decision over whether to give permission for Addison Lee to appeal a finding that their drivers are workers until the Uber judgment came out. But the Uber judgment came out, and Addison Lee have now been refused permission to appeal. And so the court is quite clearly sticking to their guns on this one. But I think that was a situation in which Uber and Addison Lee are a very similar business model. I think what we're going to see is a lot more cases like this where business setups are tested. As we said, the gig economy is trying to look for a way to employ subcontractors. They've obviously discovered that the Uber model, the Addison Lee, the Pimlico plumbers, that sort of model, okay, that makes you a worker. So the next iteration of those businesses is going to be looking for, how do we employ contractors? Employ was the wrong word, but how do we contract contractors who are definitely contractors? And I think we can see more cases like this where gig economy business setups are tested. And so it'd be a question of watching each time to see what counts towards being a worker. Where is this line in the sand? Because it's shifting at the moment. And with every case, it's been moving slightly. And so we need to keep an eye on it, just to be certain that we know, and our insureds know, are they contracting with an independent subcontractor, or are the work being carried out by a worker? In practical terms, for cases that we're actually dealing with in the here and now, the most important thing is just having a really careful look at the relationship. Ignore all of the labels attached to it. Ignore whether the insured says it's my independent subcontractor, Mr. Tapp. What does the relationship actually look like when you take away all the labels and you look at what they're doing on a daily basis, and see how that relationship works?
Right, so for now, the independent subcontractor defence is alive and well, but for it to apply, you need to have an independent subcontractor, and that category is being potentially eroded by the employment law decisions, which are broadening the category of who is a worker. So I suppose we need to watch this space for further decisions, and in the meantime look carefully, as you say, Caroline, at the true nature of the relationship when we're assessing risk for our insureds, or if we're looking for a good recovery target, because it may not be what it says on paper in reality.
Yeah.
Okay, brilliant. Well, thank you very much, Caroline, and thank you all for listening to our property damage blog today. If you have any questions in relation to the topic discussed, please don't hesitate to get in touch using the details provided. Thank you.
Thanks very much.